Yes. Uh-huh. Since I didn't get a copy of this, the date and the place of the marriage. Uh-huh. Parties were married on December 18th of 2000 in Jakova, Washington. Oh, or was it Jakova, Kosovo? Hmm. Now, to have jurisdiction over the parties, yes. I think you have to have reciprocity. Oh. And as many times as I told this court, you decided that you would falsify my identification. Yes. You would make movies. You would have false arrests. Yes. Hate crimes. Yes. And then I inform you that it violates the laws of the state of Washington in the United States. Yes. And the whole time you just sit there like, well, we're not going to enforce the law. Yes. We're not going to enforce forgery laws. No. Mm-mm. We're not going to enforce due process rights. No. Mm-mm. We're not going to enforce the civil rights of the minors named. No. Mm. We're not going to obligate the actual enforcement of the laws. So, what was the excuse for the motion for default dissolution of marriage? Yes. Because it looks to me, yes, that this can be used for default dissolution of marriage. Yes. Yes, yes. Excuse me. Yeah. Findings are based on an order of default. Ooch. On the petitioner side, yeah. The petitioner motioned the court for findings of fact and conclusions of the law. Yes. Now, there seems to be some sort of issue with these findings in fact. Are you going to give me my sons today? Today. Do you understand, Sheriff? Today. Now, I would say that for every time there's a fraudulent statement on one of these forms, Superior Court of Washington, County of Spokane, findings of fact and conclusions of law. Yes. Where the community liabilities, yeah. The parties have incurred the following community liabilities. Yes. The husband has no known separate liabilities. The wife has no known separate liabilities. The husband has incurred separate liabilities as set forth in Exhibit A. This exhibit is attached or filed and incorporated by reference as part of these findings. Yes. Now let me see. My wife said that all the debt was my decision, and you decided that I was going to pay. Well, how long does she have? Parenting plan, order for support, residential time summary report. Yes. Findings of fact and conclusions of law. Yes. Mail returned unclaimed, and that was the last entry. Yes. In the Superior Court case. The Superior Court case of 123002173. Yes. The last entry, number 48. Poop. Now, I would have thought, yes, that there was a requirement of law. Yes. But you issued this as if it were a default dissolution of marriage, didn't you? Now, my wife has incurred the following separate maintenance. Oh, it wasn't requested. Look at 2.13, continuing restraining order. Yes. Does apply. And then you put the restraining order that was issued in 2012. That was modified in 2012. Yes. Now let's see here. You had a protection order by minute order. Yes. And that it was issued by Brent Baisden. Uh-huh. On June 15th of 2012. Yes. While I was on trial. Yes. For the allegation of violating the protection order of 2011. Yes. And then Pastor Greg Miller. Oh, look at that. On October 2nd of 2012. Yes. You modified it. The same protection order. Yes. And you reissued it for a year, or you kept it at the 1 year. Oh. Uh-oh. Well, let's see here. July 6th of 2012, you issued a 1-year protection order while I was on trial. Yes. Using a minute order. Yes. And then when the jury found me not guilty, my record was expunged. Yes. And then instead of removing it, you decided to use this modification of the terms of the protection order. Order reissuing a temporary protection order. Yes. Motion hearing. Oops. Sheriff's return of service order. Motion hearing. Oh, motion hearing. Now, you must have reissued it for another year. Yeah. But as I see it, it expired on October 26th of 2013. Yes. Is that's when it expired? But she motioned the court to have it reissued for 2 more years? Yes. And it was included in the dissolution of marriage? Yes. Where I would have said, well, actually, my record's been expunged. Yes. I was found not guilty. There was no possible reason to have a protection order, unless, of course, you didn't want me to communicate with the petitioner. Oh. And when you don't give me any, well, let's look at it just for a second, Judge. Motion hearing protection order, July 6th of 2012, order for protection. Yes. Um, petition for renewal of protection order, May 31st of 2012. Yes. That had been issued on July 8th of 2011. Yeah. You reissued the temporary protection order by minute order, Brent. And then you sheriff's return of service. Then you issued it for 1 year. And then approximately July 24th of 2012, yes, 60 days after the arrest of the 28th of May of 2012, we had a jury trial where I was found not guilty. And I gave you a copy of the expungement order from Guam? Yeah. But you decided to make some more movies, didn't you? Yes. Did you give me notice of any of these court hearings? No. You just served me after you modified it? Yes. And then there was a court hearing order modifying? Oh. And then you reissued it for 1 year, or you just reissued it for the same amount of time? Yeah. I'm thinking you reissued it for 1 year. Now, that means it expired on October 26th of 2012? Yes. And then at the same time she was divorcing me? Yes. Now, if we just looked at it, just for a quick second here, yes. Let's see, was it within the 90 days? Mm-mm. Mail and publication, mail or publication. Personal service, yes, as the law says. Oh, respondent had reasonable notice and opportunity to be heard. Notice of this hearing was served on the respondent by personal service. The court requires at least 2 attempts of personal service before it can be serviced by mail. Yes. Or service by publication. Did the court commissioner not understand that there must be personal service, 2 attempts of personal service, before it can be mail or publication? Now, just looking at it, yes, this was the protection order. Sheriff's return declaration. July 30th, no, return of service. July 30th, affidavit of mailing. Order reissuing. Oh, let's see, we were divorced then, weren't we? Yeah. On July 5th of 2013, there was a petition for renewal and notice of hearing for the renewal of the protection order. Yes. 14 days later, you had another court hearing. Yes. Sheriff's return of service, not within the 5 judicial days. Oh. You can't include weekends. You can't include the date of actual service. Let's go ahead. Now, on July 19th of 2013, you reissued it. Motion hearing, proof of mailing. Yes. Now, you set a court hearing for 40 days later when the court is only allowed 24 days. Yes. But somehow you don't think the laws of the city of Seattle. You have 24 days to put it in publication or declaration of mailing. Now, she mailed it And you put it in publication. Oh. Now, did you not read the RCW of the state of Washington? Now, August 7th of 2013, it declares, yes, Heidi Lee Budnick, undeliverable mail. You have 24 days. Yeah. Now, you said you attempted personal service and you served me, but it wasn't. Well, isn't this the? Well, it's this one. Oh, the one that was modified. Yes. The one that was reissued by minute order. Yes. The one that was reissued before the actual verdict of the jury. Yes. That's the one that you included in this continuing restraining order? Yes. The one where I was found not guilty. That's what you included. Now, I'd say there's a huge lawsuit in that. See, when there's an allegation of violating the restraint provisions of a protection order, yes, and you're found not guilty and your record is expunged, yes, you cannot put in the actual findings and facts of the law of the dissolution of marriage, yes, the continued enforcement of the restraining order because